We're talking about the deniability of the police in a particularly criminal case, whether as a witness for the prosecution or for the defense. Nothing would frustrate your testimony better than the deniability of the police. That the authorities can just say that they never heard this information from you. They never received this information from you, and thus they are not obliged to validate or investigate it. So why is this important? It's because often a party would seek so that the witnesses in this case, whether the prosecution or the defense, has evidence that can be substantiated not by themselves but also corroborated by independent evidence. One of these forms of, if we can call it, validation is when the police have taken note and the police have themselves interviewed the witnesses to follow up, recorded a statement, or sought other sources of information and other evidence to verify the truth and the veracity of the information received. So how the police can validate a piece of evidence can be not just by his own interview of the witness, his own inspection of the evidence, or his own visit upon any location, but it could be by way of recording statements from other witnesses, taking photographs, obtaining bank statements to validate the assertion by showing contemporaneous transactions that happen near the time of the alleged incident. As I mentioned before, photographs, CCTV recordings, and other factors. But even the validation by the investigating officer himself does hold some weight in the eyes of the legal system. So you can see what is the effect of lack of validation from the authorities. If the authorities disclaim that you have brought this information forward to them, that a court might call into question the bona fide of that piece of evidence. Did you make it up? Is it just an information afterthought? In my country, we call it pembelaan fikiran terkemudian. Although a court of law is obliged to consider even a narrative that was provided afterthought, the weight of it would be greatly, if not severely, diminished. Our case law in Malaysia is abundant with so many decisions where the judge has rejected or disregarded a defense put up by an accused person because it was a belatedly disclosed defense, or that it was afterthought. And the definition of afterthought has expanded over time. That's why this issue of deniability of the investigator becomes even more critical. In the past, past means before I was called to the bar in 2006, it tended to be adequate for a defense counsel to put in cross-examination the defense case at the prosecution witnesses during the prosecution stage. Because in our country, we have two stages. We have the prosecution case, and if a prima facie case has been proven, established at that standard, only then does the court need to call for the accused to enter into his defense. No prima facie means the accused can be acquitted and discharged. Thus, it was good enough for a defense counsel to put the defense case to the prosecution stage and to challenge the right witnesses in the right manner. However, as time progressed, that wasn't good enough. It had to be the case that this defense put forward had to be from the accused themselves and not just from a defense counsel. So for it to have some weight, it has had to be a substantive disclosure of the defense, and it had to point out to individuals who might be better acquainted with the case. Like if the suspect wanted to name or identify or put the blame on somebody else, then it would have to be disclosed. So over time, especially in drug trafficking cases particularly, in my view, the court has imposed more and more progressively more stringent requirements on the accused. The standards and the quality and the particularity and the level of detail that is required of the accused has been progressively higher, and this puts them at a great disadvantage for many, many reasons, which I don't need to go into here. For example, the requirement that at the point of investigation where the investigating officer has recorded the statement, the accused is expected at that point in time to disclose the phone number of the actual perpetrator, his whereabouts, his full name, his nationality. If he falls short on any one of these factors, the court might diminish, not might, the court has shown that it has diminished the weight and the consideration given to that defense. It could be seen as a sham or suspect defense, a belatedly disclosed defense. And more importantly, for the subject of my discussion today, the deniability of the police. The police can more easily be forgiven by the court for not looking into and investigating further into this disclosed defense. So if there is no phone number disclosed, the investigating officer can just say, sorry, my lord, I don't have enough information for me to continue my investigation. Or let's say that if the suspect has only disclosed a nickname or part of the name, which is pretty common in real life. I mean, how many of us really know the full names of the people we deal with? They can be let off. So our expectations that a professional investigation agency would be trained and equipped to initiate or continue investigations to verify any leads provided, much more than a handful of details that's provided by the suspect under investigation. I mean, this is the target you're talking about. So you should be able to just not rely on what they say. If the suspect has provided 3 or 5 pieces of information, you should be able to meet these 3 or 5 information and interrogate deeper and look for other leads to confirm. There are cycles of investigation that I trust the investigating agencies, the world-class agencies of this world, are much more acquainted with compared to legal professionals, for example. But as far as our courts are concerned, it is good enough for the investigator to angkat tangan and surrender and say, sorry, I don't know. So we don't know if did they really give up? Did the police just give up from the scanty information provided by the suspects? Or is it intentional? It's not my place to make a case for either scenario. The fact is that this constitutes deniability. Progressively, we have seen some decisions of the superior courts on appeal where the stage where they expect the accused to disclose the detailed information, and the deniability of the police at that point in time has been pushed even earlier to the point of arrest, that at the point of the arrest, the suspect is expected to disclose to not the investigating officer, even the arresting officer, as to the details, particulars, phone numbers, whereabouts, location, description of the suspect. For example, the suspect, the other guy who had passed him the drugs, or passed him the keys of the house containing the drugs, or the car, or the account number of the bank account containing the impugned monies, for example. So this, of course, underlies and this assumption that kalau tak buat, tak salah. Kalau tak salah, tak buat. I mean, if you didn't do it, you have nothing to worry about because you will not be implicated. But that's not, it's not as simple as that. In real life, we know that there are enough people who are what we call in my country, keldai dadah, or keldai account, that they permit, perhaps unlawfully, perhaps under duress, who knows, other individuals to use their accounts, to use their cars, to use their warehouses for purposes that they're not concerned about. And because they are not concerned about this, either intentionally or because they are directed to, then the court penalizes them further and says that they have committed willful blindness. That if they are so situated with a situation that should trigger suspicion, or rather put them to inquiry, I believe that's the phrase in the test, put them to inquiry. If they fail to inquire, then they are willfully closing their eyes to a possible offense. But that begs the question, what if they did ask and the suspects deceive them? That, I think, is one of the pitfalls of that legal fiction of a test. So now we have a situation where the test has been moved earlier and earlier. From, as I mentioned, it was good enough that the defense counsel put questions at the prosecution stage. Then it was to the stage of recording statement, and now it's progressively going earlier and earlier to even the time of arrest. I mean, can you imagine a suspect who's not even represented in the jurisdiction of Malaysia, the right to counsel? I mean, there is a right to counsel indeed, to get legal advice. However, the case laws have shown that this right, although constitutionally guaranteed, it can be delayed to a reasonable time. The Criminal Procedure Code requires that upon arrest, that the police permit an arrested person to contact his lawyer or his family member. But in reality, there's often a gap in time, and that's assuming if the police actually give that right. And again, this is a matter of deniability. Deniability means that, I mean, look, if the suspect says that, I wasn't allowed the right to contact my family or the police can just simply say that, well, I did ask him, but he didn't want to. What can you do? So the element of deniability is very strong in favor of the police at that stage. So hence, I'd like to discuss here this aspect of deniability. I like to complete this first portion of this discussion that even if we go by the court's standard that they're pushing earlier and earlier, to the point of arrest, even that can be denied by the authorities. Let's say at the point of arrest, the accused says that, I did tell him that the car isn't mine. I did tell the police officer that I've got nothing on me. I did tell the police officer that I was handed these items by so-and-so person. It's very easy for the raiding team to just say, no, he didn't say that. Because in our country, we don't require body cams on the raiding team. And unless the defense side is very prepared and anticipating, this kind of transaction to happen, it's difficult to come up with any rebuttal evidence. Never mind that under Section 114 of our Evidence Act, we have an illustration there that shows that the court may presume that all judicial and official acts were conducted regularly. Therefore, unless it's like an allegation, an assertion that the cow has jumped over the moon, the court is entitled to accept what a police officer says on face value. And it is often the case, very often the case, we've seen in many judgments over the years, that the court will just say that, they are civil servants performing their duty and they have no reason to hold a grudge against the accused. They have no reason to fabricate a story against the accused. And the accused looks silly. The accused looks like this silly guy who's like accusing the police as though the police can never do any wrong. Be as it may, that is the position that we find ourselves in today. So this deniability of the police, it works not just against the persons under investigation, the suspects or the defense. It doesn't help the prosecutor either, because the prosecutor has, I think, in terms of the structure of work, the proses kerja, has less freedom compared to a defense counsel who has access to his client, who can go around looking for defense witnesses if so instructed. However, the prosecutor has to rely on what's in the investigation papers. The prosecutor has to rely on the good word of the investigator. What if the investigator was not telling him everything? What if the investigator is telling him that, tak apa, dia akan mengaku. Don't worry, this suspect, he's going to confess. Don't worry about it, tuan. Boleh tuduh, this can be charged. Of course, most police officers who investigate cases have high integrity and do not do this. Very good. But you can't close your eyes to this, that there could be some out there who are not entirely open with their prosecutor for whatever reason. It might not necessarily because of integrity issues. It could just be their attitude or how do they do their work. So deniability also affects the prosecutor. The prosecutor might ask certain questions like, upon arrest, did he say this? Or, takkan you tanya ini saja. In the course of interviewing the suspect, it cannot be that this is all that was discussed, all that was recorded. And of course, the easy thing for the investigator to do is just fall back on the recorded statement, just say that, this is all there is. In real life, there are times that a suspect could disclose other things or say things that he wants to say but it is not recorded by the investigating officer. That's why I advise that persons who are witnesses or persons who are suspects, it doesn't matter whom, have to carefully read their statements before signing. But it's not as simple as that. Sometimes a person under investigation is under pressure, or he hasn't met a lawyer, or he is, for whatever reason, he just signs off, and I've had clients who told me that when he wanted to disclose his defense to the investigator said, tak apa, cerita dekat mahkamah. Meaning to say, don't worry, you can just say what you want to say in court. So what's he going to do at that time? He can't force the investigating officer to record what he wants to say. So the effect is that the deputy public prosecutor, or rather even the senior investigating officer or the head of criminal investigation of a district who peruses the work of his subordinates, they don't have this information in front of them. So there could be elements of deniability that works against the authorities, and they'll only find out for the first time when the matter goes to trial. It's pretty embarrassing, isn't it? And when the prosecutor confronts the investigator on this, it's like, didn't you look into this? Didn't you check this out, etc., etc. That is another aspect of deniability. The investigator can just say that, no, he didn't tell me. So those are loopholes in the system, and we work on institutional good faith. Like I said, the bulk of our investigators are good chaps, good ladies and gentlemen. They do not give rise to these problems, but in the course of trial, we do see that it's as though that the prosecutor was not aware of certain facts that would have been in the possession of the investigator. So let us move on to another subject, which is how to deal with this deniability. One moment. It cannot be emphasized more that the consequence of this power of deniability is that you can get your defense rejected by the court. The court will just disbelieve it. Why? Because when you want to say that you have put forward your version of the case, it has no validation from the investigator. The investigator will deny it. So not only are you invalidated, you look like a liar. So that is very regrettable and very unfortunate. The deniability of interested witnesses against other witnesses, it's kind of understandable because people want to save their skin. But the deniability by the authorities is something regrettable, because we expect that they record in folio C, in the investigation diary, in their various folio, the truth of the case, so that they can assist the prosecutor to achieve a proper and correct decision on the case, on hasil siasatan. Never mind what they actually testify in court on oath. So deniability, as I suggested just now, if it wasn't so clear, it can happen before an indictment, before a charge. It can happen after the charge, and deniability can happen even during the progress of a trial, because these are the points in time that the investigator will be called upon to verify whether did he or she actually receive some information. And this information, like I said, it can come from the suspects, it can come from prosecution witnesses, it can come from other environmental aspects, for example. So just discussing from the point of view of the prosecutor, deniability is kind of good for you because it helps insulate your case from deleterious suggestions and challenges from the defense. Although a defense counsel is required to should challenge the prosecution case and witnesses vigorously, that's what's expected in our legal system. They should challenge it based on instructions from, there has to be a basis. And under the, is it the Criminal Procedure Code or the Evidence Act? There's one of them that says that the court is allowed to call out the defense counsel and ask, what's the basis of your question? And if they fail to substantiate the basis, then the court can actually send a complaint to the governing body, our bar council or a disciplinary board, for asking these baseless questions. So it's not that the defense counsel can simply ask, but let's say that they do, whether or not they ask with basis or without basis, the element of deniability by the investigator can insulate and protect your case. Sometimes witnesses say the darndest things, and you can't always expect, you can't coach them, you cannot control them, and you rely on the witness statements, and you should interview the witnesses before trial, but you can't always predict how the evidence will actually turn out when they put under pressure by the defense counsel or by the court. So when that happens, that might lead to a situation where you might need to re-examine or not to re-examine, leave it alone. So you'll have to make the decision. So damage done or damage mitigated as far as that prosecution witness is concerned, that's civilian. Now let's go back to, just like in a football game, the last player in the field is the goalkeeper, and the investigating officer, sometimes the last line of defense for you to save your case. It's not just for the production of documents, it's also to explain things, to cover things. Of course, you do all this according to procedure and law, and fairly, of course. But the role of the investigator and why they are powerful is that of this aspect of deniability. You see, if a witness who is acquainted with the actual facts denies things that they should know, it can be subject to adverse comments by the court as far as credibility is concerned. And the defense counsel, a competent one, will make short work of them. But as for a police officer, there's so much latitude they're given. Unless the law requires them, there's a strong requirement on them to investigate a matter that's put to them or comes within their possession, the court gives them a lot of latitude to not do anything. I'll give you some exceptions. For example, an alibi defense, because this is statutory, notice of alibi. I think Lee Kuan Yew, Vasan Singh, there's so many established authorities on this. If they fail to investigate an alibi defense, the court will hold it against the prosecution, very likely, and it's that the consequences are grave. It's statutory. But there's so many things that might come into the possession of the investigator, physical exhibits or knowledge, that if he doesn't look into it, or if he doesn't seize it, or if he seizes it but doesn't issue a borang bongkar, or he might not even admit that he came into contact with that physical object or kept it. How would you know? How would you know? How well are the police storage audited? What if he keeps it in the police, right? They have their, it depends on which agency. There's so many different agencies out there and they have different systems of keeping documents and cataloging and in inventorizing them. But sometimes they have they have a store, barang case. They have a store where they have a logbook of what comes in and out with varying levels of detail. Sometimes that's not very reliable. Look at the case of OOI CHOO HOCK, a case that handled at the High Court, and it was overturned. The conviction was overturned at the Court of Appeal for various reasons. They can keep items under their desk. They can keep items in a cupboard, or they can keep it on their person. I've seen police witnesses testify that, this item has always been in my possession, and when cross-examined, it's been in your possession for 3-4 years, and then he says yes, and the court lets him get away with it. Nobody questions, or nobody can question. So this level of accountability and inventorizing as to whether they have actually received documents or received items, it is not transparent, and it's something that investigators can wriggle themselves about. And it's difficult it's not easy to challenge them unless you have a third-party source that can confirm that for sure the investigator sees this item. Therefore, they will not have deniability over this particular exhibit. So from the point of view of the prosecutor, this deniability can come in handy. But like I said, at the point in making a decision to charge or not to charge, this deniability is actually against you, because unless you have to, prosecutors are trained not to accept what the investigating officer briefs at face value. They are trained to be critical of the evidence provided, give directions as to siasatan lanjut, rakam percakapan lanjut, to conduct further investigation and to record further statements, and so that no stone is left unturned. However, there are I mean, you cannot be sure because that's understandable. The prosecutor is disadvantaged. They're not clairvoyant. And hence that's why sometimes surprises are made only in open court, right? And it's not like the investigator will be in the corner of the public gallery and look at the prosecutor and say, sorry, I didn't tell you earlier. It doesn't work that way. Thus, prosecutors are trained and also reminded to always be vigilant and read between the lines. From the side of the defense, there are some things that we can do to manage this risk of this issue of deniability. In a moment, I'd like to revisit 3 things I missed out just now. Number one is, besides writing or doing an SD, you can also do a police report. In fact, making police report is, from my observation, one of the most popular ways for witnesses, victims, or accused to voice their discontent with how an investigation turned out. And I've seen it. Unfortunately, that's not the correct way to use it. A report should be to report or provide information on the commission or possible commission, or it's about an offense. However, sometimes the police stations have been charitable and perhaps reacting to public complaints, public pressure. They just take it and they receive everything that comes their way. So take advantage of the situation in a good way, in a proper way, and make the report. If you find that the police are unfairly denying some facts, you may find it out in the course of investigation, an ID parade, statement recording, or even in the course of trial. You can do that. Section 108A of the Criminal Procedure Code is the admissibility provision on certified true copies. You can also use other provisions of law. If it is still objected, you can attempt to say that I'm tendering this not just as that report, but it is as a statement from me, Lin Yan Cheng. Try. Just to enlarge the concept of statement of the accused, not just something recorded under the old 113, now 112. Secondly is regarding the Section 90A, subsection 7 of the Evidence Act, computer-generated documents, computer-produced documents. I think I may have been a bit strong when I use the term embargo. It's just another inadmissibility provision. It's not really an embargo. I mean, it's not to say you don't have the right. You can do it, but it will be inadmissible. And you should serve notice or information of the document. I said to the accused, sorry, that was a slip of the tongue, to the investigating authorities. Finally, I mentioned about writing to the investigating officer, specifically write to the prosecutor. You can do that to the AG's chambers because they can direct the IO to do the needful and to undertake the further investigation to recover whatever exhibits you want to offer, or to take statements of whatever new information that you have. So they can do that as well. But note that the prosecutor is not your private lawyer and is not there to entertain every single observation that you might have. Okay, that's what I like to add before we go on to the conclusion to this discussion. Very important to this issue of addressing or neutralizing or minimizing the effect of police deniability is institutional accountability. And this is manifest in, like, as far as I'm aware, in only one way, is that you can prove that the institution has actually received this piece of evidence from you. You have to prove it. So how do you do it? Because if you cannot prove it, then the police can deny ever receiving or knowing it. Even if you told them, they can just say that, no, I never heard it from this guy. And that's it. Gone. It doesn't exist. And the court would believe them. Unless you have, of course, like a third party or some other evidence, you have like WhatsApp between you and the investigating officer, or some other thing to counter that. So how do you establish that? Now, at the first step, at the stage of recording the statement, if you say something to the investigator, sorry about that background engine sound. If you tell the investigator something and they don't record it, don't sign the statement until you are satisfied you made all the amendments and they've recorded everything that you want them to say. That you want them to record. But remember, to be fair, you have to balance it. It's not like you can say everything and the IO is like obliged to be your counselor and your diary taker and your reporter. No. The investigator has a plan and an intention for recording the statement. They put the question to you and you have to answer as asked. So if they don't ask certain questions of you, then why do they need to record your answer? But sometimes when they ask, ada apa-apa lagi nak comment? Do you have anything else to say? Just treat that as an open goal. But remember, you just gotta make sure that they record it fairly. And of course, reread those statements. What if they don't record it? What if they don't? You can always write to them and request that your statement be disambung, recorded further, or you wish your statement to be recorded again. It is unlikely that they would oblige you unless there's something out of the ordinary, because you'll be called into question why you didn't mention it for the first time. Are you making something up? Were you suppressing something for the first time? Did somebody get to you or bribe you, or some unethical lawyer advise you to change your story, for example? These questions might arise, so you may be required to justify why you want to add later. So I've come across several situations where a witness tried to tell the IO something later after discovering or finding out something, but the IO just didn't want to record it. Or sometimes they will tell the IO, but the IO didn't call them for further recording statement. So what do you do? Because this is police deniability. They have the power to shut you out, and thus they can curate the case as they see fit. So you can you can send a letter which is CHOP acknowledgement to the investigator's office. Address it to his immediate superior. It will trickle down, it'll be sent down to him, but at least the boss reads it, right? And this should be done in hard copy so that you have a physical CHOP. If you go into court later and you exhibit this letter, it will be a tall order for the police to deny this. For this to bite. Yeah, the court has to believe that the letter sent to the boss to the office didn't reach the IO, right? If you send directly to the IO, you could do that, but it's good to send, as part of administrative communication, you send it to his superior. You could also do approach a commission of oaths and affirm a statutory declaration. But making a statutory declaration, the good thing about it is that it locks your statement in time and date, so that if something comes later, it's like, nope, I made it at this date, I made it earlier, and you have a commission of oaths who has locked it in time. The disadvantage of it, or rather, it becomes nearly worthless if it doesn't reach the authorities. If you do not test the deniability of the authorities, what's the point of keeping it? Sometimes you have to keep it because maybe an accused person intentionally does not want the police to record any statements, or intentionally doesn't want the police to look into this. So maybe he's holding it for now for some other reason. Maybe he has some other civil case, or he's saving it for trial. In that situation, that does call upon the prosecutor or the court to consider the bona fide of this. Like, why are you keeping this so long? Why you didn't share it with the investigating officer? Were you hiding something? Even the defense counsel, if you're not part of it, if you're part of it, there's some question marks. It could be unethical because you might be in a situation where before that SD was disclosed, you might put questions in cross-examination and you pretend as though that SD didn't exist. Would that be unethical on your part? What kind of instructions were you taking? So those are some of the risks. But let's say that if you are defense counsel and you're not part of this SD, like the witness or the client has done it himself, then there's deniability on you, isn't it? Some things you just gotta go with it because the law tells you to. This notice of alibi is statutory, so you just gotta put it through. So your defense counsel will know and the prosecutor will know that there has to be proof that it has been served properly. If there's just a notice of alibi with no proof of service, then you are risking or gambling or hoping that the investigating officer will just cheerfully admit, yes, I received this. if the investigating officer denies that he received this notice, or if this notice doesn't have at least a chop of acknowledgement, at least from the prosecutor's office, then what is your evidence as a defense that, as a part of the defense, that it has actually been served? That means it's not a notice. It's just a short, sneaky, unilateral document. It's nearly as bad as an SD which is not served. But like I said, SD has the benefit of it has an independent party, the Commission of Oath, locking the statement in time and place. Be careful, okay? Because an SD, it is an offense. You know, it's almost strict liability. I mean, it's court red-handed. If you lie, if you give falsehood, you know, and you can get in trouble. Let's say that you have a document, or that you gave to the police, or that you know that the police seized in the course of investigation, and you know it favors you on the accused side. So in the course of trial, you can actually cross-examine this investigating officer and put him to task that, hey, you knew that about this document, right? You know that I gave this to you, right? And request that he produce it in court. So this can be done either before the trial, or rather, it could be during the trial, but before this witness has been called to the witness box. It's done by a notice to produce. This is mainly done in civil cases, but in criminal cases it's done as well. And he should produce it in court. However, let's say that he refuses to produce it. Then you should attempt to show your copy, if you have it. And if you don't have your copy, your photocopy, then attempt to adduce oral evidence about its content. So the way in is under secondary evidence. Secondary evidence could be oral statements about the contents or photocopies of the original, copies of the original. So you can read up on section 65 of the Evidence Act and the exceptions. To set up this secondary evidence route, you need to show delivery of the notice to produce. These things help manage the deniability of the police, so they can't deny it, you know. So be careful too that if you are using documents that can be seen as computer generated or computer produced documents, there's a difference between documents that are just merely produced by a printer and a computer, you know, and those which are produced without human intervention and like generated. You know, there are differences in the case laws on this. I trust you are familiar of Yana Segaran, Sahar Arpan, and all these cases which discuss these subjects. Section 90 subsection 7 of the Evidence Act is an embargo. It denies the defense, it denies the accused the right to adduce evidence of, let's say, screenshots or computer generated documents that came from a device that is under his management and control. So if it's the accused's handphone and he wants to show screenshots or whatever, or something generated from his computer or his device, sorry, section 90 subsection 7 doesn't allow. So this is parliamentary deniability. It's not just the IO's deniability. If you're in that situation, what you have to do is, you got no choice. You know, you have to adduce it through the IO or through other defense witnesses, but it's better through the IO because he's a prosecution witness. And how to do this is, you got to this defense generated document, this accused generated documents, you got to consider, you got to serve it to them, serve it to the accused. But of course, consult lawyer before you do this, because there could be risks. Send it to them, tapi jangan hantar kosong-kosong. You know, have it as have a cover letter so that you can put some form of narrative, some kind of tenderable narrative, so that later you can say, I told you so, I told you so. If not then and there, even on appeal. There are also ways to tender this through third parties, like defense witnesses. But when you tender it through defense witnesses, I think you should still put it to the IO. You should still serve it on the IO beforehand and attempt to tender it through the IO. There's twofold. One is, of course, to diminish the effect of afterthought. Secondly is, if the IO had custody of it, you try Lin Yan Chen, the authority, that he has custody, so you should be able to tender it as D to the IO at the very least. and take as much opportunity to put it as much as possible through the prosecution stage. In the practice, defense counsel always talk about trying to get an acquittal at the end of prosecution case. There are many reasons for this. It's not just a dopamine trip. It's because there are many types of cases, as you know, such as our Malaysian Anti-Corruption Commission Act. We have Section 50 presumptions. Under Dangerous Drugs Act, there are various presumptions. There are so many other laws with presumptions. So much so that if defense is called, and likely the court has relied on these presumptions, you are almost dead meat. The accused person is in a situation where it's quite tough to rebut. The onus is on them to rebut on a balance of probabilities. Experience has shown that it's not that easy. Although the burden is lower than a criminal standard of proving beyond reasonable doubt, it's not that easy for obvious reasons. The accused person is not as equipped as the state of the government, and during the time that of the offense alleged, they didn't see it coming, so they didn't really prepare for it. So of course, I'm not advising you that make sure you're well prepared and well healed before committing an offense. That's not what I'm saying. I'm saying that these are the disadvantages faced by the defense. That's why we try as much as possible to put our defense and our documents through the prosecution witnesses, specifically the IO. But when you put it to the IO, they have that element of deniability that can frustrate our attempts. That's why it's important for you to show that you have served it in due course and served it properly.